Hey folks, Christina here. In this video, we're going to review Chapter 8, which is all about sales contracts. Again, this is for business law, and this information comes from the OpenStax Business Law textbook. And as you can see from the channel, this is not legal advice, so please consult an attorney if you need actual advice. All right, let's take a look at some terminology for our contracts. First, a sales contract is a specific type of contract where one party is obligated to deliver and transfer ownership of a good to the second party, who is in turn obligated to pay for the good in money or its equivalent, some other trade. The party who is obligated to deliver the good is known as the vendor or the seller. The party who is obligated to pay for the good is known as the vendee or the buyer. So, in our book, it talks about some different pieces of sales contracts. Sales contracts are consensual. This means they're perfected by mere consent without the need for additional acts. We just make an agreement, a consent, and we're good. They're also bilateral. That means both parties are bound to fulfill reciprocal obligations toward each other. They're also onerous. This means the goods sold is conveyed in consideration of the price, and the price is paid, or excuse me, the price paid is conveyed in consideration of the good. They are also commutative. This means the goods sold is considered to be equivalent to the price and vice versa. They also have what's called a nominate piece to them. The prospective buyer has the right to nominate a substitute person this to take care of the contract for them. This is mostly used in property law. Our book doesn't go into a lot of detail about that. It's just something that you should know about. Then there's principle, which is the validity of the contract does not depend on the existence of other contracts. So this would be the sales contract would be the principal contract. Now, there are a couple of sources for sales contracts, and we'll talk mainly about the Uniform Commercial Code, which is covered in our text. So let's take a look at that. So the Uniform Commercial Code was created in 1952, and it was to govern business transactions. As of today, all 50 states have adopted the code, but each state has its power to modify that code in line with the wishes of the state's legislature. There's a few categories of the UCC, and one of those are goods. Those are defined in Section 2-105 of the Uniform Commercial Code as tangible items which are movable at the time of identification to the contract for sale. Therefore, the primary feature of goods are that they are movable and tangible. Some examples are refrigerators, paper, furniture. Then the next category is services. These are items that are movable but not tangible. Some examples might be accounting, coaching, legal services. Then there is a category of realty. This describes non-good items that are tangible but not movable. Under this definition, commercial and residential properties are both classed as what we would say realty. Now, here's a bit of information about the UCC in Oregon. When a small business in Oregon pledges business assets or collateral to secure a loan or credit, a UCC-1 financing statement is required. This filing notifies other creditors of a security interest, giving the lender priority in case the debtor goes into bankruptcy. If you want to know more about the UCC, there are a couple of resources here for you. These will be in our course shell. These slides will be. All right, next up, we're going to talk a little bit about title. So a title basically means ownership of a good. And according to our text, there are three types of titles. There's a good title. You might know this as a, quote, free and clear title. This describes a title that is obtained from an individual who owns the goods free and clear. There's no loan, there's no debt on that item. The next title or title type is a void title. So this occurs when the title is passed to the buyer from a person who doesn't legitimately own the title. An important point is that good faith is irrelevant when a void title is acquired. For example, A person who unknowingly purchased stolen goods has a void title. An exception occurs when we have something that's called entrusts. So an owner could entrust goods to a merchant who ordinarily deals in those type of goods. The merchant could then sell those goods to a good faith buyer. In this case, the buyer acquires a good title. For example, in our text, it talks about a motorcycle owner takes their motorcycle to a vehicle repair shop. The motorcycle is accidentally sold and the buyer acquires the title. Hopefully, you don't take your motorcycle anywhere that accidentally sells it, but that's the example our text gave. Next, there's a voidable title. So this occurs when the contract would have been good, but certain circumstances make it voidable. Some of the examples that our text gave, if the buyer was deceitful about their true identity, if the buyer is a minor, or if the buyer wrote a bad check, or maybe gave fake cash, then the title is deemed voidable in those cases. Okay, so in our text, it gave us this example about a damaged coffee machine. So let's take a look at that. Imagine this, a cafe purchases a new coffee machine from a supplier, except when the supplier tries to deliver the equipment to the cafe, it's involved in an accident and the coffee machine is destroyed. A question emerging from this scenario is the supplier legally obligated to replace the machine? Or who holds the good title in this scenario? Now, according to our text, given problems like this, the UCC, Uniform Commercial Code, separately considers 4 different issues relating to titles. One is ownership. Under consideration is the question of when the title transfers from vendor to vendee, and then when the ownership is said to occur. If you're taking business math, we have some problems that we do that involve this very scenario. When does ownership change? When does it take place? The concept of encumbrance considers when the vendee is granted an interest in the good such that the good can be used as collateral for a debt. The UCC also considers when the risk of loss attaches and what the responsibilities of the buyer and seller are to each other should a loss occur. And then insurable interest is the right to insure the goods against exposure to risk or loss or damage. Okay, so here are 4 scenarios that are allowed right now by the UCC. First is a simple delivery contract. This is when the goods are transferred from the buyer to the seller at the time of the sale or later. Next is a common carrier delivery contract. That occurs when a common carrier who is an independent contractor rather than an agent of the seller delivers the goods. The UCC further categorizes these into shipment contracts and destination contracts. So, a shipment contract occurs when it is the responsibility of the seller to make the shipping arrangements and to transfer the goods to the common carrier. Under this type of contract, the title passes to the buyer at the time of shipment. So the buyer then bears the risk of loss, even when they haven't taken possession of the goods. A destination contract, though, occurs when the seller is required to deliver the goods to a location that is stipulated in the contract. Under this type of contract, the title transfers when the goods are delivered, but the seller bears all the risk for transportation and logistics until the time. So very important to know those 2 terms when it comes to contracts. The third scenario, according to the UCC, is goods embailment contract. So this occurs when the goods are stored under the control of a third party, like a warehouse or a ship. Transfer of the title and risk of loss depends on whether the seller has a document indicating ownership of the goods and whether the document is negotiable or non-negotiable. So here's what that means. A negotiable document contains the words, quote, delivered to the order of, and then the seller's name or seller's entity. As soon as that document is signed to the buyer, both the title and the risk pass over to the buyer. It's kind of like a paper check back in the old days. Okay, then there's non-negotiable. A non-negotiable document doesn't have those words, quote, delivered to the order of the seller. Doesn't have those words. Under these circumstances, the title passes with the endorsement of the document, but the risk of loss doesn't pass until the custodian of the goods is notified of the title. If a document is completely absent, the title passes at the same time as the execution of the contract, but risk doesn't pass until the custodian is notified of, acknowledges the transaction, and then insurable interest is created when either the buyer or the seller has the title, the risk of loss, or an economic interest in the goods. Next, we have the conditional sales contract. So this is just a contract that happens when the sale is dependent on approval. That's it. Simple on that one. Okay, next we're going to talk about warranties and sales contracts. You're probably familiar with the term warranty. A warranty is a guarantee on the good that comes as part of a sales contract. The warranty assures that the buyer, the warranty assures the buyer that the good or service is free from defects and it's a legally binding commitment. Now, the UCC indicates that performance and execution of all contracts must be taken in good faith. This means honesty in fact and the observance of reasonable commercial standards of fair dealing must be in place. There's two kinds of warranties. There's an express warranty and an implied warranty. So under an express warranty, the seller explicitly guarantees the quality of the good or service sold. There's a statement or other kind of binding document with this type of warranty. You might have something like a wrinkle-free shirt or made in the USA as express warranties. Then there's an implied warranty. This means there's no express warranty that was made, but the law kind of implies a warranty. Merchant sellers are held to a higher standard than casual sellers. So if we're a store or a merchant selling, we have a higher expectation, a higher standard based from the UCC. Now, here's some examples of an implied warranty. If I go to the store and buy a blender, I expect that that blender is going to blend food. That's an implied warranty. It's a blender. It's supposed to blend food. I think it's going to blend my food. The other example is I have an implied warranty that food I purchase at my grocery store is fit for human consumption. So that's kind of an implied warranty. We have some safety mechanisms and measures in place to make sure that food in our grocery stores is fit for human consumption. Next, our text talked about breaches of warranty. So when an express warranty breach happens, the warranty is found to be false. The person making that warrant or warranty, the warrantor, is legally liable. There are some exceptions, though. If I have a food truck and I say, I have the best sandwich in the world, that is not a contract or a warranty. So there are some of those exceptions in there. For an implied warranty breach, it's the buyer's responsibility to demonstrate that the good was defective. And design defect, manufacturing defect, inadequate instructions, or warnings for use are all things that can be taken into account in that implied warranties breach. Now, in your text, it gives some specific examples of goods under the warranty of merchantability. And this is in table 8.3, page 84 on the PDF version of your text. So there are secondhand goods, there's some descriptions there, buyer designated goods, and then food and drink. And that food and drink is kind of the example I just told you a minute ago. Sale of food and drink carries that implied warranty of being fit for human consumption. Then there is a warranty of title and some, some things that, some remedies that are available and the descriptions of those. So if there's a warranty of title, one remedy is to cancel the contract. The UCC allows buyers to cancel that contract for non-conforming goods and to seek remedies that give them the benefit of the bargain. They can obtain cover. So this means buyers are allowed to substitute goods for those due under the sales contract. However, substitutes have to be reasonable, acquired without delay, and obtained in good faith. There's a remedy of obtaining specific performance. If the goods are unique or a legal remedy is inadequate, the seller may be required to deliver the goods as identified in the contract. And then, of course, there's the remedy of a lawsuit. You can sue them. Buyers are entitled to consequential and incidental damages if there's a breach of contract. They must also be able to obtain liquidated damages, damages before the breach occurs, or punitive damages. Okay, so this chapter has loads of information. I also put in a few extra resources. These resources are provided only as an example. If you plan to enter into a contract, you should consult legal counsel prior to doing so. But if you want to see samples, there's a sample sales agreement contract here. There's a sample purchase agreement contract, and there is a sample contract that Lewis and Clark College in Oregon allowed us access to. All right, folks. Well, that wraps up the chapter on sales contracts, chapter number 8, and I will see you for next chapter, which is chapter number 9. Take care.